All right, good morning. Up next, we've got People v. Joe Green, file 24-93344FH. Counsel, you want to state your appearances, beginning with the people?
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Morning.
Your Honor, Mike Vogler representing Joe Green.
All right, and we're here for probation violation hearing on one summons and two warrants. Mr. Green has been taken into custody on the warrant and arraignment has been held. Do you know what the status is or what we're doing, Mr. Vogler?
Yes, I think we do. So with regard to most of these violations, he's going to admit to, with the exception of the drug test results, in which case he's going to no contest count 1 using methamphetamines. Count 2 and 3, where we can either have a hearing or they can be dismissed, but we're not going to either no contest or admit to those.
What about the first summons was not making support payments, not attending treatment, terminating employment, and then count 4 was using methamphetamines December 2nd.
That'd be a no contest to that one. The other 3 would be he'll admit.
And the basis for the no contest plea would be he's got other criminal charges pending on those?
Well, I would say that it potentially could create criminal charges against him, or the allegations are breaking the law here.
All right. Ms. Williams, do you consent to the entry of a no contest plea as to the drug test results?
Yes, Your Honor.
All right, Mr. Green, would you please, as best you can, raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
You can put your hand down. Mr. Green, do you understand a no contest plea has the same legal effect as a guilty plea in this court, and meaning that you'd be found responsible for the probation violation and my authority to sentence or punish you for that? Do you understand that?
Yes, Your Honor.
Do you understand that you've got the right to have a hearing on all these violations where they would need to be established by a preponderance of the evidence?
Yes, Your Honor.
Now, the rules of evidence don't apply at that hearing except as to privilege, but you'd be allowed to present evidence in your own defense and cross-examine any of the witnesses presented against you. Do you understand that? You have the right to the assistance of an attorney and you have Mr. Vogler representing you. Do you understand that?
Yes, Your Honor.
If you are found to be in violation, these consist of more than 4 violations, meaning that I'm not required to, but I could revoke your probation. Do you understand that?
Yes, Your Honor.
And you're on probation to this court for failing to pay child support as a habitual second, which means the maximum penalty that you could face would be up to 6 years in prison. Do you understand that?
Yes, Your Honor.
Has anybody promised you anything in exchange for your pleas here today?
No, Your Honor.
Has anybody threatened you to make you do so?
No, Your Honor.
Is it your own free choice?
Yes, Your Honor.
How do you, well, let's see, we'll take them one at a time. The summons from December 3rd alleges in count 1 that you failed to make payments to your child support case, regular payments, and failed to make regular payments on child support. How do you wish to plead the allegation?
Yes, Your Honor.
So when's the last payment that you made? Okay, you were required to make regular payments as part of this probation, is that right?
Yes, Your Honor.
And did you start out making some regular payments?
I made a lump sum payment.
Okay, and then it's been a while since then?
Yes, Your Honor.
Okay. You acknowledge you could have made better efforts than you did?
I do, Your Honor.
Count 2 alleges that as of December 2nd of last year, you had failed to attend substance abuse treatment. Is that true?
Yes, Your Honor.
And you were referred by your supervising agent?
Yes, Your Honor.
Okay, you just didn't follow through with that?
Correct, Your Honor.
Sorry. As of count 3, alleges that on or about October 7th, you quit your employment at GFL without notifying or getting permission from your supervising agent. Is that correct?
Yes, Your Honor.
And you knew that as part of your probation, you had to do that?
Yes, Your Honor.
Count 4 alleges that on or about December 2nd, you violated state law by using methamphetamines. And you are pleading how to that? Guilty, not guilty, or no contest?
No contest, Your Honor.
All right. And I guess for a factual basis, Mr. Vogler, you don't contest the results of those tests that the probation agent would have?
No.
All right. Mr. Green, the January 22nd warrant, count 1 alleges that on or about January 26th, you violated state law by using methamphetamines. How do you wish to plead that? Guilty, not guilty, or no contest?
No contest, Your Honor.
All right, you don't, Mr. Vogler, for that purpose, you're not contesting the results of the drug test that the probation officer would have?
No.
All right, and we'll dismiss counts 2 and 3 in the January 22nd warrant, Agent Leskey.
I believe you're talking about the January 26th warrant.
No, the January, oh yeah, I signed it then, yeah. Yeah, January 26th, it sounds like.
Yeah.
The January 22nd warrant, Mr. Green alleges that on or about January 6th, you failed to report to your probation officer as instructed. Is that true?
Yes, Your Honor.
All right, so you knew you had to report to your agent
Yes, Your Honor.
and you just didn't?
Yes, Your Honor.
All right, Mr. Vogler, you satisfied with that factual basis?
Yes.
Ms. Williams?
Yes, Your Honor.
Ms. Williams, are you aware of any promises, threats, or inducements for these, please?
No, Your Honor.
Mr. Vogler, are you? No. All right, Mr. Green, I find that your pleas are knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you have violated your probation, so I do so find. And this is more than 4 technical violations. I think what we'll do is we'll schedule this for a probation violation sentencing, March 16th at 11 a.m. And I'll ask for probation violation report to be prepared by the Department of Corrections. And Ms. Williams, the Attorney General's office may appear for that hearing by Zoom video if you wish, but you're always welcome in here in the courtroom.
Thank you.
Anything further from the people?
Nothing from the people, Your Honor.
Anything further from the defense?
Oh, yeah.
Okay, we'll see you then, Mr. King.
Thank you, Your Honor.
All right, next we've got People v. Antoine Zeno, file 25-93384FH. And we've got Mr. Vogler and Mr. Zeno appearing by video from the Crestfield County Jail.
Yes, sir. Good morning. Happy Groundhog Day.
And I have a plea agreement in front of me here. Who's on this case?
I am, Your Honor.
All right, do we have an amended information?
If I may approach, Your Honor.
Yes.
Yeah, I'll call this.
All right, Mr. Vogler, have you seen this amended information?
No, I have not.
I think it's wrong. Count 4 alleges attempted assault with intent to do great bodily harm less than murder or by strangulation. The principal charge is a 10-year felony. This attempted purports that it is still a 10-year felony. Wouldn't it be a reduction to the 5-year?
If I may, Your Honor, it is a weird how it appears, but if the court will look to that second paragraph in count 4 after to say if offense is attempted is punished, and then after that it says felony 5 years. I believe that was supposed to be dropped down to the next paragraph, Your Honor. I do believe that that's just a spacing and formatting issue.
Okay, but then below it, it says felony, 10 years or $5,000. Why should that be anywhere there?
Your Honor, we generated this morning. Our software is hinky.
It's wrong. I can't accept, this is a charging document and it's wrong legally. I'm tendering it back to you. File it correctly.
Yes, Your Honor.
I don't care what the software is. I don't care if you have to manually type it. It's got to be legally correct.
Yes, Your Honor.
Mr. Vogler, you content proceeding with the felony information amended to be filed later?
Yes.
All right, Mr. Zeno, would you raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can put your hand down. Now, Mr. Zeno, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have. So I want you to listen carefully. If you have a question, ask me. I'm happy to answer it. If you need some time to talk to Mr. Vogler, you just tell us. We're happy to give you that time. Do you understand that, sir?
Yes, sir.
Now I have to advise you the maximum penalty that you could face for these charges. The added count, well, it says added count 3, but it'd be an added count 4. Is that right?
Yes, Your Honor.
Okay. Added count 4, attempted assault by strangulation would be a felony punishable by a maximum of 5 years and or a $5,000 fine. Do you understand that?
Yes, sir.
All right. Are you on probation or parole anywhere?
No, sir.
Were you on bond for any other cases at the time of this incident?
No, sir.
Did you read and understand the rights listed on the advice of rights form?
Yes, sir. Yes, sir.
Okay, and I've got a form here that you signed tail end of last week. Is that, did you sign that form?
Yes, sir.
Do you have any questions for me or your lawyer about any of those rights?
No, sir.
Do you understand if you plead guilty, you won't have a trial and you'll give up all those rights?
Yes, sir.
And is that what you wish to do today?
Yes, I do.
If I accept your plea, you give up any claim that it was caused by any promises beyond the terms of the plea agreement, and you give up any claim that it was caused by any threats. Do you understand that?
Yes, sir.
Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission. You would do so by filing an application. But the types of issues that you could raise on an appeal after pleading guilty are very limited, much more limited than if you were convicted after trial. Do you understand that?
Yes, sir.
All right, the plea agreement provides in exchange for your plea of guilty to the attempted assault by strangulation, the remaining charges will be dismissed. This was there's also a plea agreement for a county cap if the plea is entered by the docket call. So there were some comments that this was contingent on waiver of the prelim and that sentence agreement was only had a time deadline of today. Do you understand that, sir?
Yes, sir.
Mr. Vogler, is that a full, fair, and accurate statement of the terms of the agreement?
Yes.
Mr. Wirgo?
It is, Your Honor.
All right, Mr. Zeno. That sentence agreement for the county cap is not binding on me. If I wanted to give you prison, I wouldn't have to be limited to by that county cap. But if I did not follow that county cap, you would be allowed to withdraw your plea, not having received what you bargained for. Do you understand that?
Yes, sir.
There is an important exception to that, however. Here's what it is. If you engaged in any misconduct between now and the sentencing, bond violations, violations of court orders, or misbehaviors in the jail, or criminal conduct, by your own misconduct, you would forfeit the right to withdraw the plea, even if I didn't follow that county cap. Do you understand that, Mr. Zeno?
Yes, sir.
Other than this plea agreement, has anybody promised you anything to get you to plead guilty today?
No, sir.
Has anybody threatened you to make you do so?
No, sir.
Is it your own free choice to enter the plea?
Yes, it is.
Knowing all this, how do you wish to plead to the charge in added count 4, attempted assault by strangulation?
Guilty.
And Mr. Vogler, would you assist with the factual basis, please?
I will, Your Honor. So Mr. Zeno, on October 23rd, 2025, were you in the city of Rogers City here in Presque Isle County?
Yes.
And on that particular day, did you get into an argument with Tanya Trojanowski?
Yes.
And during the course of that argument, did you attempt to stop the argument from continuing by grabbing hold of her?
Yes.
And one of the things that you did when you were grabbing hold of her is you took your hand and you placed it forcefully, and I'm just going to illustrate, into her chin and over her mouth.
Yes.
And did that cause her breath or her ability to breathe to be impeded? Did it impede her ability to breathe?
Well, yeah.
Yes or
Yeah.
no? That's all we have, Your Honor.
Okay, you satisfied with the factual basis, Mr. Vogler?
I am.
Mr. Wirgo?
Your Honor, I did not catch defendant's answer to that last
Yeah,
question.
Mr. Zeno, did you answer yes to that last question, that it did impede her ability to breathe?
Yes.
Satisfied, Your Honor.
Okay, very good. Mr. Vogler, are you aware of any other promises, threats, or inducements?
I am not.
Mr. Wirgo?
None, Your Honor.
And Mr. Vogler, in your judgment, has the court fully complied with the requirements of MCR 6.302?
Yes, Your Honor.
Mr. Wirgo?
The court has.
All right, Mr. Zeno, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of that offense, so I hereby accept your plea. We'll schedule sentencing for March 16th at 10:50 a.m. And you'll have to cooperate with a pre-sentence interview so they can write a report for me with recommendations about what the proper sentence should be. Mr. Vogler, anything further from the defense?
No, Your Honor.
Mr. Virgo, anything further from people?
No, Your Honor.
All right, Mr. Zeno, we'll see you then, sir.